There is no person known to law as the anonymous justice of the peace. So what does that mean? Well, in essence, it means that judges can't be anonymous. Judges make very important decisions about matters, and the idea is that the public are entitled to know who is making such decisions. However, there's been a departure, and there's quite a lot of controversy about it. So what's brought this on? It's that really sad and horrible case of Sara Sharif. She was the little girl who was returned to her father despite his background showing that he's perhaps not the best person to be allowed near a child. And ultimately, it all ended in tragedy. Now, he has been sentenced to imprisonment, has been convicted of the M word, but people are looking into this and saying, well, how did he get custody? I mean, we don't use the word custody in family law now, but I mean, that's a common term. How did he get custody when there was a record of people saying, well, he's just not suitable? Now, in fairness to the judge, the anonymous judge, part of the issue here was they were saying, well, it was a very inexperienced social worker who did the assessment, and she said there was no risk. And there's also criticisms of the way that other bodies looked at this, and criticism of Kafkas generally and all that sort of thing. But the argument is, well, this is all well and good, but we need to see the decision-making process, and also, these people need to be named. And that is, generally speaking, the normal position on that. And I'm just going to read you out something from a relevant case. Now, interestingly, this case, what made me feel really old is, this is a 40-year-old case, and I was just sort of thinking it was like almost like something back in the Victorian days, but actually it was an application by a journalist friend of mine, David Lee. And I'm going like, that can't be 40 years ago. But this is what the judges had to say in that particular case, where there was an application, because in that particular case they'd anonymised. This was a decision made in the magistrates' court. This was again a really sad case where somebody had allowed a child to live with some people, and it ended very, very badly. Now, that was a decision made in the magistrates' court, and what the press said is, well, we need to know who the magistrates were, but also who is the legal advisor, or what back then would have been the court clerk, because magistrates are finders of fact, but when it comes to the law, in terms of how do they apply the facts they have found or to the law, or vice versa, it's the legal advisor who effectively advises them what to do, but they are supposed to take the legal advisor's advice on the law, as written in stone, because generally speaking, lay magistrates don't have any legal qualifications of their own. We also have what we call district judges, the old stipendiary magistrates, and they are actually qualified lawyers. But in this particular case, it was a lay bench and a legal advisor. And the papers said, we need to know who these people are. And this is what the judge actually said in the application to, unanonymise them. There is no way to be found in any statutory provision or rule which entitles a justice to anonymity in any circumstances. The naming of a justice is scarcely referred to in legislation. I have found 2 instances of it. By Section 8, subsection 4 of the Magistrates Court Act 1980, a report of committal proceedings may be published which contains the identity of the court and the names of the examining justices. Rule 36 of the Magistrates Court Rules 1981 provides that any record kept in pursuance of a rule in domestic proceedings should indicate the names of the justices constituting the court by which the decision was made. So far as I have been able to ascertain, anonymity has never been claimed other than by a number of justices I have mentioned by anyone who can be said to be a judicial or quasi-judicial person. This applies as much to High Court judges and circuit judges as to, for example, members of tribunals. An inspector at a planning inquiry is, by statutory instrument, disentitled from being anonymous. It would, I think, be thought outrageous by trade unions and employers' associations if they were not entitled to know the identity of members of employment tribunals. Many of the persons I have mentioned are subject to criticism vilification even at times, and suffer from being pestered by telephone or otherwise by persons who bear some grievance, and moreover, occasionally by being approached by the press. But such intrusion into their private lives, judges and others have inevitably to put up with as a tiresome, if not worse, incidence of holding a judicial office. So what they're saying there is, look, if you volunteer to do this job, you're not conscripts. So whether you are, a lay magistrate, somebody sitting on an employment tribunal, a planning inspector, all the way up to being the most senior judiciary, it's tough. You get named and people are allowed to speculate about you and comment on you. And yes, we accept there can often be a danger to you. You might go beyond that, but that's not a reason to depart from the usual rule. So it might be we need to give you better security or something like that, but that's just something you have to put up with. So in this particular case then, with the Sara Sharif case, it's a number of journalists, including Louise Tickle, who I've mentioned before. She does a lot of very good reporting on the family court system. So she has applied and said, look, we need to know who this judge is, who made these decisions. Because when they've looked into it, it seems it was the same judge all the way through. And he did two what we call public law cases, hearings on this. That's where it's the local authority dealing with it. But also what we call a private law one. That's one between the sort of mum and dad. And in that particular case, he found that this child should be returned to the dad. There was one other judge was actually involved in this case, and he actually made an emergency order saying that, interfering and saying, hang on, there's something not quite right here. This child shouldn't be left unsupervised with this person. Now, we don't know who that is either. But obviously people are more concerned about who's the judge who sat on 3 separate hearings and said this person is safe. Now, it may well be that the judge's argument would be, I can only go with what I am being told by the professionals in this case. It is always difficult, because one of the reasons that we say, well, you can criticise the judiciary, but bear in mind they are not allowed to answer back. But again, that's just something you have to put up with. But they made the application, and the court at first instance has said, no, we are not going to allow you to name this judge. Also, they didn't give permission to appeal that decision. So now the journalist will have to go to the Court of Appeal and say, we would like to apply for leave to appeal this decision. It'll be very interesting to see what happens there. And, I will follow this very, very closely, because, the idea is it's all meant to be about open justice and transparency. And yes, there is the counter argument that, it puts people at risk. And you can have anonymity in some cases for like witnesses and things. In criminal cases, for instance, it might well be that, you let the police use your property for, observations or something like that. And those observations going at trial, we were watching people arriving at these premises on a regular basis because we suspected there was dealing going on there. In that particular case, they'll say, yeah, the person who let you use the house can remain anonymous, because otherwise nobody would cooperate if they knew that their name was going to be out there and, the gangs could come after them. Also, especially in family proceedings and child proceedings, they maybe say, well, we don't have to name every witness, especially young witnesses. Children are entitled to their privacy. So you get a lot of this in litigation, where it'll be like child A, child B, child C, things like that, because they say, look, you've got to protect them. It's quite a scary experience, and you don't want the press knocking on some sort of 11-year-old's door saying, can you tell us about your experiences and why you said this and why you said that. So there are times when we do depart from this. But you remember the police officer in the shooting, where the judge said there, it's in the public interest that they should know who this person is who's been charged with this. And there was a lot of controversy about that. But I know a lot of people argue and say, well, hang on, if it's good enough for police officers to be exposed, especially when they have bounties on their heads, why shouldn't judges be named, brackets and shamed, if they've made questionable decisions, assuming it is a questionable decision. But, part of the issue is, well, we can't really see this. I mean, we need to see what is the reasoning that the judge made these rulings, but also, who is it? Can we have a look? Is there a pattern there? Is this a judge who's, decision making seems to be erroneous or to show a particular pattern, things like that. I mean, and this is the rule. This is the role of the press. The press is not just a watchdog. Sometimes it has to be a bloodhound, to quote the authorities. So yeah, I just thought you might find that sort of, as always, vaguely interesting, vaguely useful, vaguely informative, and vaguely accurate. I think I've got most of it right because I actually did read the relevant bit out there. But I'm very interested in what you think. I mean, what can anybody say? Well, there are good arguments for letting the judges be anonymous. To stop them facing undue criticism, or indeed, and we've seen certain events in America, that might put them at risk. But I know you're all very keen on freedom of expression and transparency in the legal system. So yeah, let me hear your thoughts. And somebody said, sit on the left and you'll be right. Quite a serious subject, so I'll pull a serious face.